Morning. This short video will be a continuation of the application of Jones and Katz to the curtilage of a person's home. If you remember, we previously said in reference to the curtilage that if there's a physical trespass onto the person's curtilage, which is that area that is immediately associated with the person's home and those activities that the person carry on within his home, then there's a violation of the Fourth Amendment if that trespass is for the purposes of gathering information that's going to be used for future prosecution. However, there's another group of cases that deal with the curtilage and access to the curtilage. That is aerial surveillance. In Florida versus Riley, the government got a helicopter and they flew within 400 feet of the person's property in order to make a determination as to whether he was involved in drug activity. And doing this, they were able to get information to get a warrant to search the person's home. Riley said, "You violated my Fourth Amendment protection because you violated the curtilage." The court said, "We hold we would have a different case if flying at the altitude had been contrary to law or regulation. But helicopters are not bound by the lower limits of the navigable airspace allowed to other aircraft. Any member of the public could have legally been flying over Riley's property in a helicopter at the altitude of 400 feet and could have observed Riley's greenhouse. The police officers did no more." The court basically held that if the uh, public could do it, the, the government can do it also. However, it must be within legal airspace. And if the government is flying within legal airspace that's permissible to the public, then the government can gather that information, and it will not be a search in violation of the Fourth Amendment. But the court went on to say, "Neither is there any intimation here that the helicopter interfered with respondents' normal use of the greenhouse or any other part of the curtilage. As far as this record reveals, no intimate details connected with the use of the home or curtilage were observed, and there was no undue noise and no wind, dust, or threat of injury." Here the court is saying that it is not necessary that all flying over the home uh, will not be a violation of the fourth, even if it flies within navigable airspace. If there is a seizure, here's what the court is saying. The seizure occurs if there's significant interference with the person's use of his home. If there had been wind that had blown, if there had been noise that was interfering with the person's use of his home, if there had been some interference with the person's use of his home, then we'll have a seizure, and that would be a violation of the Fourth Amendment. Let's move on to another group of cases, another case, and that's a case that deals with trash. The trash, in this case, Greenwood, California versus Greenwood, person placed his trash on the curb outside of his home. It was not on a curtilage. We're not dealing with the curtilage here. He placed it on a curb outside of his home. The government got information that Mr. Greenwood is involved in drug activity. They asked the refuse company to get Mr. Greenwood's trash and to bring it to them. And they brought the trash to them at the behest of the government. The refuse company got the trash. They brought it to the government. The government found indication that Greenwood was involved in drug activity. They did a second search. Or they got a second group of trash from Greenwood's home, and they got the same information that he's involved in some type of narcotic activity. And they used that information. To get a search warrant in order to search his home. Greenwood says, "Hold it. You have violated my Fourth Amendment right by going into my trash, by going into the trash. Trash will contain a lot of intimate information that persons want to dispose of. I put it in an opaque bag. I protected it. I said that I wanted to have a right to privacy, and this right to privacy should be one that is honored. That should be honored by the government." The court said no. Basically, what the court said that we conclude that respondent exposed his garbage to the public sufficiently to defeat their claim to Fourth Amendment protection. It is common knowledge that plastic garbage bags left on the side of the public street are readily accessible to animals, children, scavengers, snoops, and other members of the public. Moreover, respondents place the refuse at the curb for the express purposes of conveying it to a third party. Basically, what the court is saying, two principles, and the two principles we've somewhat already covered, is that if you expose it to a third party, if you expose it to a third party, you run the risk that the government, it will be exposed to the government. And second, they're saying also is that there's no reasonable expectation of privacy and something that you place outside of your home. There's no reasonable expectation of privacy because the public has access. If the public has access, the government will have access too. And so the only thing that Greenwood did was, again, confirm those two principles. If the public has access, the government will have the same access. And if there's criminal activity, the government will have access, and the government will be able to get a warrant in reference to that particular criminal activity. Next, the principle is that if you reveal it to a third party, you assume the risk that the government will get access here, will get access also. And here it was revealed to the refuse company. And once once Greenwood revealed it to a refuse company, then he ran the risk that the government would also have access to it. Now, if we move on from Greenwood. I'd like to move on to another case. And this case deals with the cell phones and the right to privacy on cell phone. And the cell phones, basically, the case of Carpenter, or United States versus Carpenter, it dealt with cell site location information. It dealt with cell site location information. In this particular case, the government got a warrant, but it was not a warrant that was based on probable cause. It was only based upon reasonable suspicion under a special provision dealing with cell phones or dealing with this type of information. They got a warrant. The defendant claimed that, look, the warrant is no good because you need probable cause in order to search my cell phone, or not search the cell phone, but in order to get that cell site location information, you're going to need probable cause. And the question became whether the court needed or whether the government needed a search warrant for the purposes of getting cell site location information from the provider. And in this particular case, the provider provided over 128 days of information and thousands of pages of information in reference to Mr. Carpenter's location, in reference to Mr. Carpenter's travel. Then the case became, and the court decided, and the court said that cell phone CSLI information is historical information. It's historical information, and that this historical information, if it's gathered by the government, an individual maintains a legitimate expectation of privacy and the record of his physical movements as captured through CSLI, cell phone site location information. Cell phone location information is detailed, encyclopedic, and effortlessly compiled. For that reason, society expectation has been that law enforcement agents and others would not, and indeed in the main simply could not, secretly monitor and catalog every single movement of an individual's car for a very long period. As with GPS information, the timestamp data provides an intimate window into a person's life, revealing not only his particular movements, but through them his familiar, political, professional, religious, and sexual association. Basically, what the court is saying, that if it's historical information, because of the amount of time that this information can be stored on this cell phone, that is infinitum, that is at least for 5 years, that we can go back and gather this information, this cell site location information. And that cell site location information tells a lot about the person, of all those intimate activities that the person, a lot of intimate activities that the person would not want to reveal to the public. Whether that person goes to the doctor, whether that person eats regularly, all that information can be gathered, and that information can be used against that person. The court said that you will need a warrant based upon probable cause in order to get that cell site information, that cell site location information, because that historical data digs into the intimate activities or reveals the intimate activities of that person's life. And therefore, they required that a warrant, that the government get a warrant. However, However, the court went on to say, our decision today is a narrow one. We do not express a view on matters not before us. Real-time cell site location information or tower dumps are going to be legal without a warrant. We do not disturb the application of Smith and Miller. Smith dealt with and Miller dealt with the principle that if you reveal it to a third party with telephones, you reveal it to the telephone company, and if you reveal it to a third party, then the government has access also. But with Smith and Miller, they were only revealing telephone number and not the historical data that is captured by that CSLI, that cell phone site location information. And so Smith and Miller are still good law. Conventional surveillance techniques, we're not overturning conventional surveillance techniques and tools such as security cameras, nor do we address other business records that might incidentally reveal location information. Further, our opinion does not consider other collection techniques involving foreign affairs or national safety. And so the government, within its decision, uh, developed several exceptions to this cell site information principle in reference to the cell phone. And basically, the rule is that in reference to cell site location information, that the government will need a warrant because of this historical data and the amount of information and the intimacy of that information that the government may gain. And that information is something that a person would seek to keep private. And therefore, the government would need a warrant in order to get that information. With that, I'm going to stop this video and we'll pick up and continue with the application of CAT.